Hello, welcome to CAT 4884. In this session, we will discuss the functions and relationships among laws, regulations, and professional organizations in information security. We will also address the differences between laws and ethics. We will discuss major national laws that affect the practice of information security. In addition, this session will explain the role of culture as it applies to ethics in information security. As an information security professional, it's very important to understand the organization's legal and ethical responsibilities. The organizational information security must be to date adhering to the latest laws and regulations. In addition, security practitioners must watch the threats or must watch for the threats and issues that need attention with their practices. To be vigilant and understand that new laws will minimize liabilities, reduce risk from electronics, and reduce losses from legal actions. Before we go further in this chapter, let's understand the meaning of both laws and ethics. Laws are rules adopted for determining expected behavior in modern society, and as individuals, we elect to trade some aspects of personal freedom for social order. Laws are drawn from ethical or ethics, which are defined as socially accepted behavior. Ethics are based on fixed moral attitudes or customs of a particular group. Some ethics are recognized as universal among all cultures. As we stated before, knowing the laws will minimize companies' liability, and based on that, we need to define some of the concepts or some of the terminologies that we will see during the course. For example, liability. Liability is a legal obligation of an entity extending beyond criminal or contract law, includes legal obligation to make restitution. In the case of information security, the company should be liable for their customer personal information. The company will be dealing with lots of data, lots of personal information that includes social security number and the home address, the name, date of birth. All these personal information are very important to secure. So any loss of information, they are liable. The company will be liable for that loss. When we say restitution, restitution is compensating customers for wrongs committed by an organization or its employees. The company is responsible for the loss of the data. So for that, they have to accept or to make restitution for their customers. Training should be provided to ensure employees know what constitutes acceptable behavior and know the consequences of illegal or unethical actions. Ensuring that employees know what is acceptable is called due care, while due diligence is defined as making a valid effort to protect others, continually maintaining a level of effort. And that's why you see signs everywhere when you go to a store. It will tell you that you're not allowed to touch this, or you're allowed to do this, or you have to walk between these lines. And all these instructions are called due diligence. They are making sure that they are informing you on what is the right behavior or the way to do it, so they will not be liable for any mistakes. Jurisdiction is the court's right to hear a case if the wrong was committed in its territory or involved its citizens. Long arm jurisdiction is the right of any court to impose its authority over an individual or organization if it can establish jurisdiction. In an organization, we usually hear the word policy. So what's the difference between when we say policies and laws? Policies are defined as the list of expectations that describe acceptable and unacceptable employee behaviors in the workplace. Policies could be considered as laws within an organization and must be written carefully to ensure they are complete, appropriate, and fairly applied to everyone in the company. The law is a system of rules and guidelines that are enforced on all people. To enforce policy in the company, the written policy will be distributed to all company's employees where they will have the chance to read and comprehend. Sometimes we distribute it via email, paper. It will be posted everywhere in the company. So you have to use different distribution methods within the company to make sure that everyone has that policy. Read that policy. And even if you want, you can make them sign that they did read it and comprehend it. Once being read, the employees have to comply and follow company's policy. The enforcement will be fair, equal, and uniform through all departments. There are several types of laws. We're not trying to understand the whole, law system. We're not lawyers, but we try to understand as much as relate to us as information security professionals. So we know that there is something called civil law, which represents a wide variety of laws that are recorded in volumes of legal code available for review by average citizen. The criminal law, which addresses violations harmful to society and is actively enforced through prosecution by the state. The tort law, which allows individuals to seek resource against others in the event of personal, physical, or financial injury. And then we have the private law, which regulates the relationship between the individual and the organization and encompasses family law, commercial law, and labor law. The public law, which regulates the structure and administration of government agencies and their relationships with citizens, employees, and other governments, providing careful checks and balances. Examples of public law include criminal, administrative, and constitutional law. There are lots of international laws related to information security. Actually, the United States has been a leader in the development and implementation of these laws, especially now we are trading globally and we have more business on the international level. So we need to have these kind of laws established to be able to communicate with other countries and other entities. The established international laws assist in creating a reliable business environment and more stable economy. There are specific penalties for individuals and organizations failing to follow requirements set of information security laws. So what are the different US laws related to information security? Let's start with general computer crime laws. The Computer Fraud and Abuse Act of 1986 is the uh, cornerstone of many computer-related federal laws and enforcement efforts. It was amended in October 1996 with the National Information Infrastructure Protection Act of 1996, which modified several sections of the Computer Fraud and Abuse Act and increased the penalties for selected crimes. Severity of penalties judged on the purpose of commercial advantage of private financial gain in furtherance of a criminal act. The USA Patriot Act of 2001 modified a wide range of existing laws to provide law enforcement agencies with a broader latitude of actions to fight terrorism-related activities. So we gave more power for law enforcement through that act. The Communication Act of 1934 was revised by the Telecommunication Deregulation and Competition Act of 1996, which attempts to modernize the archaic terminology of the old act. These much needed updates of terminology were included as part of the Communication Decency Act, and the Communication Decency Act was immediately trapped in a spiky legal debate over the attempt to define indecency and ultimately rejected by the Supreme Court. Another key law that is of critical importance for the information security professionals is the Computer Security Act of 1987. It was one of the first attempts to protect federal computer systems by establishing minimum acceptable security practices. The National Bureau of Standards, in cooperation with the National Security Agency, became responsible for developing these security standards and guidelines. Information privacy is an important issue and has been discussed widely recently. There's privacy in invading your information, knowing your some information about you or your behavior. All these are like privacy issues that considered as invading of privacy. And what are the limits? So the ability to collect information on individual, combine these facts from separate sources and merge it with other information has resulted in a huge database of information that were previously impossible to set up. Now it's possible. Big data. We have something that's called big data. So the aggregation of data from multiple sources permit unethical organizations to build database of facts with frightening capabilities. They know a lot about each person. So what will be the limit? What is the limit? Companies know their customer behavior and can predict what he or she will do next. Isn't that scary? What is the limit? There are US regulations to ensure individual privacy. One of the most common rules or regulations is the privacy of customer information section of Common Carrier Regulation. This rule this regulation specifies that any exclusive information shall be used explicitly for providing services and not for any marketing purposes. It also stipulates that carriers cannot disclose this information except when necessary to provide their services. The only other exception is when a customer requests the disclosure of information, and then the disclosure is restricted to that customer's information only. The Federal Privacy Act of 1974 regulates the government in the protection of uh, individual privacy and was created to ensure that government agencies protect the privacy of individuals and businesses' information, and to hold those agencies responsible if any portion of the information is released without permission. The Electronic Communication Privacy Act of 1986 regulates the interception of wire, electronic, and oral communications. The ACPA Act works in conjunction with the Fourth Amendment of the United States Constitution, which provides protections from unlawful search and capture. The Financial Service Modernization Act, or Graham-Leach-Bliley Act of 1999, requires all financial institutions to disclose their privacy policies on the sharing of non-public personal information. It also requires due notice to customers so that they can request that their information not be shared with third parties. The Act ensures that the privacy policies in effect in an organization are fully disclosed when a customer initiates a business relationship, as well as distributed at least annually for the duration of the professional association. Another common and most important U.S. regulations is the Health Insurance Portability and Accountability Act of 1996, or what we call HIPAA Act, and also known as the Kennedy-Kasipom Act. This act impacts all healthcare organizations, including small doctor practices, health clinics, life insurers, and universities, as well as some organizations which have self-insured employee health programs. The Act requires organizations that retain healthcare information to use information security mechanisms to protect this information, as well as policies and procedures to maintain this security. It also requires a comprehensive assessment of the organization's information security systems. Not only the system, but also their policies and their procedures. There is no specification of particular security technologies for each of the security requirements. Only that security must be implemented to ensure the privacy of the healthcare information. The privacy standards of HIPAA severely restrict the dissemination and distribution of private health information without documented consent. The standards provide patients the right to know who has access to their information and who has accessed it, and also restrict the use of health information to the minimum required for the healthcare services only. The access to customer personal information could lead to identity theft. If they know your name, you know their birth date, they know your social security, then they could steal your identity and utilize it to do other unethical or unlawful things. So, which occurs when someone uses your personal information and the information that is published or that should be protected by the organizations and the entities. So if they can access your information through those businesses or these organizations, they can get to your information. That's a problem. And they could steal your identity, and again, they can do unlawful things with it. It happens all the time. So if you suspected that your identity has been stolen, what do? You need to report to the three dominant consumer reporting companies, Equifax, Experian, and TransUnion, that your identity might be stolen. You need to close compromised accounts and dispute any new accounts that have been opened without your permission. You need to register your concern with the Federal Trade Commission. You need to report the incident to either to the local police or to the police in the location where the identity theft happened. On the other hand, there are export and espionage laws to protect businesses. In an attempt to protect American ingenuity, intellectual property, and competitive advantage, the Congress passed the Economical Espionage Act, or EEA, in 1996. This law attempts to prevent trade secrets from being illegally shared. The Security and Freedom through Encryption Act of 1997 was an attempt by the Congress to provide guidance on the use of encryption and provide measures of public protection from government intervention. The U.S. copyright law, as stated in the previous lecture, business intellectual property has been targeted by hackers. As a result, intellectual property is recognized as a protected asset in the United States. So the U.S. copyright law extends this right to the published word, including electronic formats. Fair use of copyrighted material includes the use of support news reporting, teaching, scholarship, and a number of other related permissions. So long as the purpose of the use for educational or library purposes, not for profit and not excessive. From the financial side of business, there was a Sarbanes-Oxley Act of 2002, which included reforms in corporate governance and the accounting profession. The reform or the act intended to improve corporate financial reporting and internal control, strengthen audit committees, change the relationship between the auditor and the client, improve auditor independence, provide additional auditor assurance over internal control, and provide oversight and regulation for auditors of publicly traded companies. The Freedom of Information Act of 1966 provides any person with the right to request access to federal agency records or information not determined to be a matter of national security. The U.S. government agencies are required to disclose any requested information on receipt of a written request. There are exceptions for information that is protected from disclosure, and the Act does not apply to state or local government agencies or to private businesses or individuals, although many states have their own version of the Act. In addition to the national and international restrictions placed on an organization in the use of computer technology, each state or locality may have a number of laws and regulations which impact operations. It's the responsibility of the information security professional to understand state laws and regulations and ensure the organization's security policies and procedures comply with those laws and regulations. Information security professionals can create a matrix to align companies' policies and procedures with state laws and regulations. Companies outsource their operations and produce their products overseas. In addition, they sell their products using internet. Companies are not limited to a certain location within one country. They are globally connected to the international community, as I stated before. Based on that, professionals must be sensitive to laws and ethical values of many different cultures, societies, and countries. In addition to the political complexities and cultural differences, there should be an international laws um, to protect businesses from both sides. Although these international laws are important, they're limited in their enforceability. Recently, the Council of Europe drafted the European Council Cyber Crime Convention, designed to create an international task force to oversee a range of security functions associated with internet activities and to standardize technology laws across international borders. It also attempts to improve the effectiveness of international investigations into breaches of technology law. This convention is well received by advocates of intellectual property rights with its emphasis on copyright infringements prosecution. Another international collaboration is the agreement on a trade-related aspect of intellectual property right that was created by the World Trade Organization. The agreement drafted the first significant international effort to protect intellectual property rights. It outlines the requirements for governmental oversight and legislation, providing minimum levels of protection for intellectual property. Agreements cover 5 issues: application of basic principles of trading system and international intellectual property agreements, giving adequate protection to intellectual property rights, enforcement of those rights by countries in their own territories, settling intellectual property disputes, uh, transitional agreements while new system is being introduced. The Digital Millennium Copyright Act is the US version of an international effort to reduce the impact of copyright trademarks and privacy infringement, especially through the removal of technological copyright protection measures. The European Union also put forward Directive 95/46 EC that increases protection of individuals with regard to the processing of personal data and the free movement of such data. The United Kingdom has already implemented a version of the directive called the database right. In the next lecture, we will talk more about ethics and ethical issues related to information security. For now, that will be all for this session. If you have any questions, please let me know. Have a great day.